Chapter 10, Force and Coercion, Part 1. In this particular PowerPoint, we are going to examine the use of deadly force by police. And the landmark case in this area is Tennessee v. Garner, a Supreme Court decision from 1985. And so what happened in this case is as follows. And I'm just going to list several things here. This was a case out of Memphis, Tennessee. It actually occurred in 1974, so 1985 is when it was finally decided by the Supreme Court, but it takes a while for cases to work their way all the way up to the Supreme Court and be decided by them. So what happened was the Memphis police received a dispatch call that there was a prowler inside a particular house at a particular location. They didn't get much more information than this, and this is often problematic in police use of force situations where the police just don't have much information. Maybe it's a dispatch call, maybe it's something that they observe themselves, but they only observe part of something going on. They don't know if it's dangerous or not. Well, in this situation, it was a dispatcher call, and there wasn't much information other than there was a prowler inside. When they arrived at the address, it was two police officers who arrived. When they arrived at the address, they saw Edward Garner. They didn't know who he was at the time, but later they would find out his name was Edward Garner. They saw him running out into the backyard. The police hollered to stop. They hollered, "Police, halt." Garner crouched at the bottom of a 6-foot-high fence and made a motion as if he was going to try to jump over it. One of the police officers fired a shot at Garner and ended up killing Edward Garner. As it turns out, Edward Garner was a teenager. He was unarmed. He had about $10 worth of items that he had stolen from the house. And again, he was killed by the police. Garner's father brought a 1983 lawsuit, a Section 1983 lawsuit. If you remember back to our discussions about legal restraints on the police, we talked about Section 1983. It's part of the federal code, and it was passed shortly after the Civil War, and it's used to allow private citizens to bring lawsuits when they feel that their rights, their federal rights, have been violated under color of law, so by police, by other lawful authorities. And in this instance, Garner's father alleged that when the police shot and killed his son, Edward, that was an unreasonable seizure under the Fourth Amendment. Now you might be saying, well, how's that the case? Isn't a seizure just an arrest? Well, remember that the definition of seizure is the police have given notice that this person is not free to go. And if you shoot and kill someone, you have given the ultimate notice that they're not free to go. So this is what Garner's father was alleging, that the police shooting of his son, when his son was unarmed, was not presenting any kind of threat to the officers. I mean, the officers even testified they did not kill him because he was threatening them or anyone else. They were only killing Garner because they were worried that he was going to get away. And they were operating under something known as the fleeing felon rule. And we're going to take a closer look at that in just a second. But the fleeing felon rule, in essence, is a rule that said, or it was a rule that said, that police could use all force necessary, even deadly force, to bring about an arrest of a felon who was fleeing. So the police officers weren't worried about Garner shooting them, hurting them in any other way, or shooting or harming anyone else. They didn't believe that he was armed. They didn't believe that he was a threat. The only reason that they shot him was to stop him from getting away. They were operating under the fleeing felon rule. So what Garner's father was alleging was that the fleeing felon rule constituted an unreasonable seizure under the Fourth Amendment and the 14th Amendment through incorporation. So the challenge was to that fleeing felon rule, and the Supreme Court was asked to determine if such a rule was constitutional. Now you might initially have the knee-jerk reaction that how could such a rule be constitutional? How could we ever say that the police could kill someone merely because they suspected this person was a felon and was trying to get away, even if that person presented no threat to anyone? Well, we have to go back to some of the history of the fleeing felon rule. It dates back centuries. And so if we go back to those centuries when it first started, we can maybe see where it was justified. So what are some of the justifications initially for the fleeing felon rule? And then we have to question whether those justifications are still valid in 1985 when the Supreme Court decided the case, or if they're valid today. So one of the justifications was, when this rule first originated, there were very few felonies. Mostly these were crimes that were very serious. They really were only the core crimes of things like murder, rape, robbery, burglary, those kinds of things. Things that we thought were inherently dangerous, and by definition, they might have been punishable by death. And so the crime itself that this person was suspected of, that fleeing felon, was something that was inherently dangerous and something for which they could be put to death, at least potentially. So we could understand why it might be acceptable to kill a fleeing felon even before they get to court, because again, they were suspected to be inherently dangerous, and the death penalty might be waiting for them anyway. So again, felonies were inherently dangerous. There were very few of them. We could, with just a little bit of thought, realize that that's not true today. The only felony that's punishable by death, in general, we could talk about treason and those kinds of things, but those rarely come up. But in general, the only felony that is punishable by death is murder. And so we don't punish rape or burglary or robbery with death anymore. So even if you're guilty, even if we catch you, you're not going to face death unless you've murdered someone. And even then, it's highly unlikely that you're ultimately going to be executed. About 50 people a year in the United States are now executed every year. So, the odds that you're actually going to be executed for this are very low. So that old notion that felonies were punishable by death, that there were very few of them, both of those things aren't true today. We have lots and lots of felonies. If you unlawfully download music or a movie, you might have engaged in a felony. Are we lying awake at night worried about people who are downloading movies and music? No. And so we wouldn't say that person is inherently dangerous. If the police catch them and they try to run away, the police should kill them. No one would say that. So we have lots of felonies these days. They're not all inherently dangerous, and they're certainly not all punishable by death. So those first two justifications seem to be off the table. Next, another justification for the fleeing felon rule is if we go back a couple hundred years, there weren't any police departments, and the weapons that the people might have been using who were trying to apprehend this fleeing felon were very limited. You were probably in face-to-face, hand-to-hand combat. If you were able to kill this person yourself, you were probably already facing a risk from this person. I mean, they were struggling against you in probably close combat. So in essence, you were right there. You're dealing with somebody who you suspect to be inherently dangerous. They are struggling with you. Your weapons are limited. So there's an implicit risk to your life at this point. So it's not like today where we could have a sniper who, in the military, we have confirmed kills of over a mile by snipers. And certainly the police officers in Tennessee versus Garner did not feel threatened by Garner and were not close to Garner when they shot him. They were many yards away. They were across a backyard lawn away from him. And so, again, we have weapons now that have greater range, greater accuracy. There isn't necessarily an inherent risk in the struggle to subdue and capture this person or to kill this person. Back then, there were very few means to find and apprehend the person after they escaped. I mean, if someone committed a felony in what is now State College back in the early 1700s, they were in the middle of the wilderness. They could easily escape. If they got away, they were probably away for good. And what's worse is they could go into some other neighborhood, some other community, create a whole new identity, because obviously we didn't have photographs, we didn't have driver's licenses, we didn't have any photographic means of identification, that this person could create a whole new identity. As long as they didn't run into somebody who knew them, they could continue to commit crimes and no one would be the wiser. Well, even in 1974 when Garner committed his crime, or 1985 when the Supreme Court decided, or today, we have means to apprehend people. If we really want to find them, we can try to track them down. We can send out APBs. We can send out other notices. We can use television, internet, all kinds of things. We can maybe bring in CSI to try to find clues to identify the person. All these kinds of things. Also, there isn't, most people aren't really willing to, just because they committed a crime, suddenly vanish off the face of the earth and go off the grid, so to speak. I mean, when Edward Garner committed his crime, if he had gotten away, it wasn't likely that he was going to leave Memphis and go into, some mountain cabin and live off the land. He was a 16-year-old. He was a teenager. He didn't probably have those skills. So again, people aren't likely to just suddenly disappear off the face of the earth like they could have a few hundred years ago. So our means to find and apprehend are much better. And as I said, back then it was easy for the offender to establish a new identity and reoffend and commit crime after crime after crime again. So if they got away, they were likely to continue their dangerous activity, or at least there was a greater possibility than today. And so we could see that these were all valid justifications a couple hundred years ago. Today, I mean, if you haven't caught the drift already, none of these really hold up. We don't need the fleeing felon rule anymore. If we want to really catch this person, then we can. And so the Supreme Court decided that the fleeing felon rule was an unreasonable seizure. It was unconstitutional. Police can no longer use all force necessary to bring about an arrest. The court pointed out that an arrest is the first step in the process, or at least one of the first steps. And if we allow the police to be judge, jury, and executioner, we have defeated the whole reason that they were trying to catch Garner. They were trying to catch him to bring him to justice. If they shoot and kill him, they've defeated that whole process. And so the Supreme Court said, fleeing felon rule, whatever justification it might have had at one point in its history, it is no longer justified anymore. It is an unreasonable seizure. So when can police use deadly force? Well, it's not to catch a fleeing felon who presents no threat to anyone. Instead, police may use deadly force in really two situations. One is self-defense. So if they are facing a deadly threat or a threat of serious bodily injury to themselves, and it's immediate, they may use deadly force. If they're acting in defense of others, so you're a police sniper and there's a hostage situation and it becomes really evident that this hostage taker is about to kill hostages, and the only way you can save them is by killing the hostage taker, you can use deadly force to take that person out because they are presenting an imminent, immediate threat, and we can see it here, an immediate threat of death or serious bodily injury to another person. Those are the situations, those two situations, in self-defense or in defense of others, when police may use deadly force. In no other situations may the police use deadly force. That's it. And don't think of the movies where the police officer shoots at somebody's hand to try to wound them and say, well, that wasn't deadly force if they happen to miss and hit somebody in the leg or anything. If you fire a shot at somebody, whether you're aiming at their hand or their heart, that is deadly force. You better be able to justify it through self-defense or defense of others. So it's not the movies where you're going to shoot the gun out of the person's hand. If you've made the decision to shoot somebody, and I know this sounds harsh and maybe you'll misunderstand what I mean, but if you've made the decision that the factors and the situation warrants the use of deadly force, then that person should be dead. You shouldn't be wounding them. You shouldn't be shooting the gun out of their hand. You should realize that you have determined that the situation is dire enough that the only way you can resolve it is by killing this person. So if you've done your job, the person should be dead. And I know students, when I've said this in my classes on campus, students have misunderstood and they think I'm advocating for the police to kill more people. I'm not. I'm saying that we need to drive that point home so that the police officers understand that this is the only time when they can use deadly force. When they've reached that absolute extreme where this person must be stopped, they must be killed, then they can be justified in using deadly force. If we allow police officers to think it's okay to wound people, that somehow that's a lesser standard, you're going to have more people dead. You're going to have more police shootings. So we need to make it clear to them, you've made the decision that the only way you can resolve this is by killing this person. Don't be wounding them, kill them. Okay, that again sounds harsh, but that's to bring home the point that deadly force should be reserved for the most extreme situations. Only when there's an immediate threat of death or serious bodily injury to you, the officer, or to someone else. Now, after Tennessee versus Garner, there's kind of an extension of the defense of others. It may sound like the fleeing felon rule, but it really isn't. The Supreme Court recognized that if a suspect is fleeing the scene, but with the intent to immediately do harm to someone else, serious bodily harm or death, cause death to someone else, then the police may use deadly force to stop that person. So we're not talking about, this is a person who is running to their car and it's a 2-hour drive to the victim. But this is where this person is running away from the police and they're headed straight to the victim, who maybe lives down the street. And if the police don't stop this person, and the only way they can stop this person is by killing them, that person's going to kill that other person. So this isn't really the fleeing felon. This is basically acknowledging that the immediate threat requirement of use of deadly force in defense of others is expanded a little bit. But it still requires some immediacy. Again, this is someone who is going to immediately kill someone. Maybe that victim is not at the scene right now, so technically speaking there isn't a threat of an immediate threat to another, but it is very close by. I mean, this is something that if this person gets into their car and drives, in 5 minutes they're going to kill somebody, because they're going to speed to the scene and they're going to kill that person. Or they're running down the street, and if they get to that person's house, they're going to kill them. And the police have only one means left to stop that person, to prevent the murder, and that's to kill the suspect. So again, that may sound like fleeing felon, but it really isn't. It's really an extension of the immediate threat requirement. In terms of what we know about police deadly encounters, we don't know a whole lot, and that may sound surprising. You would think we would know more about when police kill a suspect or kill a citizen than anything else that the police do, but we don't. There is no law that requires police to report an incident of police shooting another person or killing another person in any other way. We don't have any national database. We don't have federal laws that require this reporting. And so we don't have the information on it. And that may be surprising, but we really don't know how many people are killed each year by the police. We just have guesses. For a long time, the guess was about 1 a day. So about 300 people a year. But that data has recently been called into question. We think it's much higher than that. And so the Washington Post created a database a couple years ago. I believe they started in 2015. And they've been continuing to compile the information. So this is information the government should be collecting, but they're not. But what the Washington Post has done, and if you go to the PowerPoint version that isn't a video, that isn't a YouTube video, but if you go to the original PowerPoint, and even if you just go to Canvas, I have the link in a separate location to the Washington Post database. You can go and check it out for each of the last couple years. And what the Washington Post has done is they have assigned people within the Washington Post to scour all the news coming out of the various states. And anytime there's a report in the newspapers or on the internet or on the local television news or wherever of a police shooting that results in the death of a person, they document it as well as they can. Now sometimes they can get a lot of information. Maybe the news report gives extensive information about this, what happened. Was the person armed? Were they suffering from a mental health issue? What race were they? What gender? Do we have the age? You might find all this information. And in other situations, most of that information is lacking. It may be just a paragraph that says, in an incident the other day, the police shot a citizen, and maybe they give the person's name, and that's it. And so there's not much information. So again, as good as the Washington database is, it still has some problems. They wish they could be more complete, but it does give us a truer picture of police shootings in the United States. And what the Washington Post has consistently found over the last couple of years is that about 1,000 people are killed each year by the police. And you can go to their database, you can click on different factors and do your analysis. You can look at individual states. So if you want to see Pennsylvania and see all the reports and how many people are killed in Pennsylvania by the police, you can go and click on Pennsylvania and see that information. It's about the best information that we have right now, to be perfectly honest. And so what we really need, if we really want to understand lethal force, deadly force by the police, we need the government to compel reporting of information and thoroughly report the information. Include a lot of factors like race, psychological condition, whether the person who was killed by the police was armed, what crime were they suspected of, if any, all of these kinds of things. And so we really need that information. Surprisingly, except for the Washington Post database, we really don't have it.